All right, I'm going to call the docket. When I call the docket, you need to answer and let me know you're here. Samantha Venegas. Samantha Desiree Venegas. And she's on bond, correct? Araceli Robles. Johnny Aguirre.
In custody.
All right, thank you. Ray Espinoza, custody. Arturo Villanueva, thank you. You're always on time. Riot Aguilar. Thank you. Travis Mann. Thank you. Anthony Villarreal. Anthony Villarreal. All right, thank you. Mark Morgan.
President Council.
Thank you. All right, we're going to take up the cases at 9, and then as soon as the jury is here, someone will be in jury trial. And everyone, please confer.
So you need them right away, right?
Yes.
He's walking.
All right, thank you.
Okay. Mama, I called.
On top of it.
Yeah, you would have felt that one real quick. Good morning.
Wow. Casey really goes on.
Yeah. Is your family out member else here? You can be talked to. Your employee number? Morning. Yes, sir.
You send me.
Do you remember which one that was?
Yeah, right here.
Hello. How's it going? Good.
Hey, so I was in a Zoom hearing yesterday.
Mhm.
And I hit the more option on one of the buttons on the bottom. And guess what popped up? An
What?
option to disconnect your audio. And that is the thing that you need to do
That's how you do
on
it.
your iPad. So that might be an easier way. I didn't know.
Okay.
Zoom's always changing the program, so
Okay, so just click more.
that's a new thing.
Well, the
And-
only thing that one doesn't do an update, I don't think.
Oh, really?
Yeah, at least I don't think so. But we'll
could
check
still-
it out
It could still be on there. Just
Okay.
check the settings.
and just
all that.
do more.
I suspect there may be a way to have that be your default.
Oh,
in-
please,
In the settings, but
you are welcome to try. You're like, no.
I'll let your capable IT people take care of that. But it is an option.
Okay, awesome.
I was like, that was the first time I'd ever seen that, so I think it must be an update.
Okay,
So anyway,
all right,
hopefully that'll
thank you.
kill the feedback.
All righty. I appreciate that so much.
I have it on. I'm just trying to see. Retro. You pointed back in 2003?
Yes.
23.
Yes.
All right, who is the case with the motion to revoke the contested? Okay, and she's not here.
Nor the church,
All right,
the CSO is present.
all right.
Yes, yes.
Any objections to court calling the attorney?
No, Your Honor.
Okay.
No.
Can you believe that, Bashan, Jason? That's my regular routine to run a 5K, so it's nothing special.
It's a free one, Judge.
Okay, you know what, Bashan? The gauntlet has just been thrown down.
He hasn't met us not one time. Not one time, and they're free.
Mayor, why have you not gone with the 187 for the 5K? Well, they have one coming up Saturday. Okay, so
No, what he is asking, he hasn't joined either.
you haven't done a single one. I've even got out there knowing that somebody may need to carry me, but I still made it. Oh, yeah, okay, we need to do the turkey trot. I like that.
It's a District Court Heroes 5K this Saturday at Port San Antonio. I'll forward it.
All right, do we have to wear a hero outfit though?
Judge, what have you worn an outfit?
I'm gonna go with Storm. You know, Storm has some major powers people don't recognize because of the way they play her in the, the movies. Yeah, but in the comics, she and Jubilee really bring the fire.
I thought she was pretty strong in the movie. She was like controlling the weather and lightning.
Yeah, but see, there's more terror powers than just controlling that. Like she can call on the earth and do certain things.
Oh, okay. We need to check out those comments. Yeah.
Oh, yeah.
Sorry. I didn't know what Mandel.
No, Judge, for this weekend, I really would like to have at least 2 days off.
Yeah. You act as though we were working on Saturday and Sunday. Hello.
Nate? First row?
She has a case here in a county court.
Here.
Yeah, she has, no, it's in Dutch Mountain. Knock it off. That's the pre-indictment report. And then she has her in county court. And that's all I have. Remember me?
Samantha Venegas. Oh, that's you? All right. Anthony Villarreal. Thank you. Thanks.
That's easy.
Mayor Pro Tem,
Yes.
on today's docket. Morgan.
All right, can I see the file on Mark Morgan, please? Mark Morgan, where are you? Come forward. No gum chewing? It's from yesterday.
Oh.
So, Mr. Morgan, the state has filed a dismissal in your case. The reason they put for the dismissal is there's a witness that's not, present that they need in order to prove their case. So, whatever brought you here today, don't come back for this. You understand?
I don't normally come back.
Okay.
Yeah.
All right.
Yes, Judge.
All right.
Definitely have that conversation.
Thank
as well.
you.
All right. Thank you. Thank you for dressing appropriately for
Thank you.
court.
Maybe excused, Your Honor?
Yes.
Thank you.
Thank you.
All right. Thank you.
Oh, yes. Yes. I'm telling you.
You put it on your phone.
All right. Can I see the parties on, Samantha Venegas, please?
Good morning.
I was just checking our case to see. We had revocation or not, I'm not sure. It's when not, no, that's fine. That's 1 second. That would be for all his cases. Yeah, it has several pieces of. Make sure there's not this one. Okay. No, it's good. No, no.
Oh, wait. It's just- Here's the check sheet for you. This comes- Sharing sheet.
And excuse me, Norma,
Yes.
would you call Ray and Victoria and tell them they need to be here now?
37.
Thank you.
You're welcome. Okay, thank you. Bye-bye. Judge, how early is too early for Christmas decoration?
Oh, you're not supposed to put up Christmas decorations until the day after Thanksgiving.
Not day of Thanksgiving?
No.
Day after?
Yes,
4 minutes, Your Honor.
sure. Okay, thank you.
Let me put you through this. If I-
Okay, one more.
Yeah. I think that's something.
No, tell them not $3.99 if they need to be here. Siobhan. I don't know who's Siobhan.
I'm gonna call her to the stand now. Not gonna listen.
All righty, thank you. All right, if you'll pull Raymond's case, please.
Yeah, just in case 399 called, I got a call last night, that was number one for trial, and the jury's in the hall,
Okay.
and counsel sitting at the table,
Okay.
and I walked out on them.
Oh, thank you, Raymond. See, I'm like, you're so awesome. All right, if you'll have your client, if y'all want to just stand, is it just one witness?
Yeah,
All
sure,
right.
we can do that. You don't mind, Judge, I'm gonna ask my client, if she's okay to stand, she's got a.
Oh, we'll have her sit in the chair. That's okay.
Or be in pain.
Oh, no. All right, court is calling 2022 CR 3083, State of Texas versus Araceli Robles. You can have a seat.
Thank you.
Could I have the parties announced for the record for the state,
Jason Garahan, Your Honor.
defense?
Raymond Martinez.
And are you Araceli Robles? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? And did you understand it? All right, you're gonna need to keep your voice up so the court reporter can hear.
Yes.
Are you the same Araceli Robles who was placed on deferred adjudication in 2022 CR 3083 for the offense of possession of a controlled substance, penalty group 1, 4,200 grams, on May 9, 2022 for a period of 5 years? Is that you? All right. State?
Yes, Your Honor. First, Your Honor, we're waiving, the violating conditions number 1, each of them.
And there are 2 number ones?
There's 3 number 1s.
All right. Any objections to those waivers?
No, Your Honor.
Would you like me to proceed with the
Yes.
violating condition number 2, on or about the 20th day of September 2023 in Bear County, Texas, the defendant
Araceli.
Robles did in there failed to submit the drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 13th day of December 2023 in Bear County, Texas, the defendant Araceli Robles did in there failed to submit the drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 31st day of January 2024 in Bear County, Texas, the defendant.
Oh, just 1 second. If you could slow down a little bit for the court reporter.
On or about the 31st day of January 2024, Bear County, Texas, the defendant Araceli Robles did in there illegally use of controlled substance and methamphetamine in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 22nd day of April 2024 in Bear County, Texas, the defendant Araceli Robles did in there failed to submit to the drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 13th day of May 2024, Bear County, Texas, the defendant Araceli Robles did in there failed to submit to the drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true? She's pleading true to the last one.
Yes, Judge.
Pleading true to that?
Yeah.
Okay.
Did you understand by pleading true to the last violation? Number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? All right, then the court will find that violation of condition number 2 true. And that's the violation that's dated on May 13, 2024. All right, state, do you have witnesses?
We do, Your Honor, but in lieu of her being true to number 2, the waiver of other violated conditions.
Any objections to the waiver of the other violations?
No, Your Honor.
All right, then your client then is withdrawing her plea of not true, correct? For those violations, since the state is.
Well,
waiting.
since they're banning them, yes, that's fine, Judge.
All right, so then the violations that are waived without objections are 1, 1, and 1, and 2, 2, 2, and 2 will be waived without objections, and the court will allow your client to withdraw her pleas of not true. All right, any witnesses?
No, Your Honor.
All right, then is there an agreement?
No, there's not.
All right, state, what are you requesting?
The state's gonna requesting revocation, Your Honor. I know that the state is recommending safety, the state would be recommending revocation.
All right, defense, what are you requesting?
Judge, we're requesting that she be continued and that inpatient treatment either be held in abeyance or maybe possibly put on her probation for a time when she can actually do it. I know probation is interested in her doing that. That's one of their recommendations. As the court is aware, she has new number 1s pending, which are an obstacle to her going to inpatient. However, that could theoretically be resolved at some point. The reason for the delay at this point, Judge, as you can see from her condition, she was in a very serious car accident, not in the very recently, within the last couple of months. What was the date? Well, been longer than I thought, July 30th. She has a broken leg. She's currently being treated for an infection in the bone. They've got her on a series of medications. So for her to go and try and do that right now, that could have very damaging effects to her treatment. It doesn't look that bad and she's able to get around, but in fact, it is broken and the doctors are concerned about the infection that is currently ongoing. And so she has been reporting to probation. It's my understanding that she's been clean recently, and I think she can stay on that regimen. She's also involved in some civil litigation regarding the car accident. It wasn't her fault. She got hit pretty hard by a big truck. And so it's in her best interest long-term that she get her medical treatment, number one, that she comply with probation and with her lawyers and stays clean for purposes of the civil litigation. But she also understands that there's going to be sanctions from the court, and we're not asking the court not to impose them. We're just asking that we do them in a fashion that addresses everybody's concerns.
All right, any objection to the court reviewing the court summary?
No objection.
No, Your Honor.
All right, probation. Let me see if I can find the court summary. All right, thank you.
And just for the court's purpose, defense counsel, we do have our community supervision officer here in court today. Yvonne Salcedo.
Oh, well, let's call Ms. Salcedo as well.
Yes. This Salcedo.
Good morning. Good morning, Your Honor. All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you can state your name for the record.
My name's Yvonne Michelle Salcedo.
Any objection to the court just asking general questions?
No, Your Honor.
All right, so her answer may be a narrative. How was she doing on probation before this motion to revoke was filed?
Ms. Robles was reporting, like she was supposed to be. She was showing signs that she might have a substance abuse problem because she was testing positive and there was a confirmed test. She sometimes failed to submit her UAs when she was supposed to. And so every time I would ask her when she was reporting, to be honest, and if she could just admit that she was having issues so that we could get her the help she needed. And I also tried to get her to attend some of her support meetings. And she was trying, but she got arrested. So that's where we ended. The next step, if she had been arrested, would have been for me to have recommended safe SADOF, the substance abuse treatment facility.
All right, so you said she was trying. What actions was she taking to try?
So she did submit some sober support signatures that she was attending sober support meetings. She was reporting once a month on a regular basis. She would contact me if she could make it and we would reschedule her. But she always kept in communication with me. So I had a feeling that she wanted to stay on probation. She wanted to really get through it. But at the same time, she did have substance abuse issues that she was denying.
All right, any other questions from either side?
Nothing to say, Your Honor.
No, Your Honor.
All right, thank you so much for coming in. Is this witness excused?
Please, Your Honor.
All right,
Yes, Your Honor.
all right, you may be excused. Thank you for coming in. All right, so this is what's going to end up happening. Number one, if I were to continue you, you're going into inpatient treatment. And it's not going to be held in abeyance. So with regards to this leg infection, what medical report do you have about that?
I have to take a 12 weeks antibiotics.
No,
But do you have a report?
Oh, yeah.
The commission to-
Any objections to the court reviewing?
No objection, Your Honor.
All right, this antibiotics for 12 weeks, when did it start? And when does it end?
It started on, just had,
Because I have a date of admission for surgery as 10/25.
Sure, it had to have been after that, Judge.
So it says take one tablet twice a day for 12 weeks.
it was big.
I think she's been doing it for the first couple of weeks, Judge, so she's 2 weeks into the 12, maybe.
Well, it appears that they gave her this October. Do you have your medication with you?
No, I don't know.
Why wouldn't you have it with you? It's supposed to be taking tablets twice a day, so you would have to take it in the morning at least.
Yeah, I took it in the morning. Quarantine.
All right, so what I'm telling you is it appears that this medication was given to her on October 25th.
No,
Okay.
I was admitted on the hospital. I got discharged on,
Yeah, because what it says here is they gave you this medication on the 25th. That's what it says. That a list of your medications are all on here from October 25th.
I think they discovered the infection based on my conversation with her after she'd already been released from the hospital.
If you don't want to review that.
I apologize for my text, Judge, but court in 390 is calling me.
Okay,
I'm just
no
telling you,
problem.
I'm just telling you I'm here. And she's calling.
the appointment.
And
Judge, I would-
so
I
by
would
the
refer
court's
court-
calculation, the 12 weeks will put her the week of January 6th.
On page 5 of 13, Judge, it indicates that she has a follow-up on this on December 16th in regards to the infection situation for them to review how she's doing.
All right. Anything else from either party?
Nothing else from.
All right,
the state,
and
Your Honor.
state, and you're still requesting revocation?
Yes, Your Honor, and if not revocation, we're in request safety, and if not safety, it's drug court.
All right, this is what I'm thinking of doing. We can go off the record. And this is what I'm weighing. I realize that infections, when you have a broken leg, they're very serious. And this is not really a death penalty case. So what I'm considering doing is ordering that she goes to safety. And she'll need to report to court on December 17th. And then do a referral to felony drug court to see if felony drug court will accept her. And the referral to felony drug court is going to happen today. They're going to do a referral for that today. So you'll be doing the process of felony drug court. Do you understand?
I'll explain to her, Judge.
Judge, I do want to make sure that you're aware that we did refer her back in 2022 and she refused to participate. So I would like the court to strongly encourage.
All right.
participation if she is accepted.
Here's my question for you. Do you want to participate in felony drug court? That's either yes or no.
I'm not sure she understands what that means, Judge.
All right, that means you know what it means. And let me just tell you why you know what it means, because you were interviewed before for felony drug court. And obviously you have a drug problem. That's why we're here, because you're not doing your UAs and then they waived it, but you've been tested positive for meth as well. So these are your two choices. Well, actually 3. 1, I can send you to prison. You don't have to do felony drug court. You can go to prison. They have a prison hospital, and the prison hospital will give you medications. Either your leg will remain or you will lose it. Or you can be interviewed for felony drug court. If you get over there and you tell felony drug court you don't want to be in felony drug court, you're immediately going to safety. So my question for you is, do you want to be interviewed for felony drug court or not? I don't understand why that's a difficult question. Guess what?
She wants to be referred for felony drug court, Judge.
All right, we can go back on the record. This is what's going to happen. I'm going to deny the motion, alter and amend conditions that she's to be referred to felony drug court. If she tells felony drug court that she does not want to be in felony drug court, then she's immediately going to safety. All right. And if for some reason felony drug court doesn't accept her, we're going to have a hearing to see if she's immediately going to safety. Does everybody understand the court's ruling?
Yes.
I do, Judge. I'll make sure she does.
All right, so I'll deny the motion. Alter and amend conditions to include a referral to felony drug court. If not accepted, then she's to be brought back to the 187th. For a referral to safety. Is there anything else from either side?
Clear on it.
Do you understand the court's rulings? All right, thank you.
Thank you, Judge.
Oh, and I think 399 is calling
I
you.
know, I just told Norma that.
All right.
I guess I know it's-
Yes.
Yes, try.
All right. Yes.
Judge, I just wanted to thank you for your assistance while I was out of town on Mr. Asparian.
Oh, you're welcome.
Kind of.
All right, you're welcome. And everyone, we're just waiting for the jury to come up. And Mr. Foley, just ask them to pull the file if you're ready to discuss your client.
I'm sorry, Your Honor. Approach.
Yes.
I didn't hear you.
Oh, just ask them to pull the file if you're ready for us to discuss your client.
Yes, Your Honor.
Thank you. Bashan, on that case, does it need to be extended at all?
Judge
I think,
currently expires in 2027.
okay, all right, we're good then.
Do you want to set her compliance hearing in December though?
Yes.
Or-
So we can put that for, I think, December 17th, because she said she has an appointment, I think, on the 16th with the doctor. We'll put it the week of December 16th, whichever date you think is best. Oh, compliance, I'm sorry, a compliance for the felony drug court?
Will felony drug court and an update on the medical situation?
Yes, well, she said that her medical, she's not gonna have an update till, I think she said December 16th.
Okay.
Where's Miss Robles?
She went outside, Judge.
All right, I think she said December 16th, but if we can set it after that and then find out what felony drug court has said.
Okay, good.
Yes, sir. Whatever you guys. Number 19. No, I mean, the 20.
Oh, don't say that.
And what date did you want it set?
The 19th.
Okay.
That's if she's not accepted as a felony drug charge.
Yes.
Just what's happening with the other two cases, I could.
I don't know. Jason. On her other cases, what is, on the other cases for Araceli Robles, what are the plans for those cases?
Well, Judge,
Because felony drug court is not gonna accept her.
I
technically.
realize that and I was gonna bring it up, but I was gonna review them to see what type of cases they were. I mean, I know there's 2 drug cases and evading.
Okay.
It depends on how much.
Okay, all right.
And so I can review those and then, I mean, she can still get evaluated. Is that-
Oh, yeah,
okay.
she'll still be evaluated, and then
maybe
maybe,
that'll be determined of whether I can, if I'm willing to.
Yeah.
But she's on deferred, so.
yes, and then it's something for you and the defense to discuss.
Yes.
All right, thank you.
Uh,
All right, Ray Espinoza.
I'll follow your honor on behalf of Mr. Espinoza.
All right. So on this case, I'm assuming you all have all of your discovery
We do, your honor.
and an offer has been tendered.
I offer. An offer has been tendered, your honor. I need to discuss it with the client, but I have a feeling we're not going to accept it.
All right, so how old are you? 19? So I'm gonna give you a plea deadline date and I'm taking into consideration your age. So we'll come back on. Norma, recall this on December 16th.
Yes, ma'am.
We'll come back on December 16th. At that time, you'll need to let the court know whether or not you've reached an agreement with the state. You understand?
Mhm.
If you haven't reached an agreement, your next setting is going to be a trial setting.
Yes, ma'am.
All right, anything else?
Thank you, your
Uh,
honor. No.
All right, so if you all can do an acknowledgement of discovery for me on his cases. All right, thank you.
And you said the
16th,
December 16th?
yes.
Thank you.
And Judge, I'm sorry to ask again, so you want me to send the Robles case on the 16th as well? Or say it a little bit earlier?
Whichever date you want to put it on, it's just to see if she's in felony drug court, then we won't need to reset her.
You want me to put it on the same page?
Sure. Yes.
Why are they even opening them?
This shouldn't be in.
It should not.
My settings.
There's no difference. It was just an empty.
Sorry, Judge.
Oh, no problem.
Oh, I'm sorry.
One, two. 3, 4, 6, 7, 8, 9, 10, 11, 12, 13. 13.
What's the difference? Never trial from smoker.
Somebody's.
Very different. Frankie. Motion is Robert can put the ball on.
Yeah.
Okay.
Additionally, there's not a right on the case, it's something else, but I need a very budget strike.
Jim, so you get sent to there, if not, I'll run to the back to go grab you some paper. Is there any there? No. I'm sorry, I cannot hear.
It's the living room.
Still on, right?
And Naomi, can you see where, Stolhansky is?
Yes.
Okay. That one is very like. Oh, that one would never fit in that, both just on the side. And Norma, can you see if, Jenny Callahan is available? They did a waiver for jury on this, so I just want to see what date would work for everybody. Oh, Denny, you're hiding back there.
Whatever you say, Your Honor.
All right, so Miss Venegas, if you can come forward, please. All right, it's the court's understanding that you wish to have a bench trial, and you understand what all of that means?
Yes, ma'am.
Okay. State, on this bench trial, how long do you think it would take?
Day and a half or 2 days. Well, it's a bench trial. Oh, we have 4 or 5 witnesses, Your Honor, and that's including the drug handler? Yes. Okay.
All right, so do you all want to confer with Ms. Ferguson when you all would like to do the bench trial?
Sure.
All right, so if y'all would confer on a date, so we won't do your case today since it's going to be a bench trial. Your attorney in the state will confer with the coordinator to see what's the date that works best for everybody involved, okay?
Thank you,
welcome.
ma'am.
All right, and then Norma, if you could see if we could perhaps do this before the new year, if possible. Yes, sir. Oh, and state on this case, you all are going on the drug case?
I'm sorry, Judge.
You all are proceeding on the drug case and not the evading.
They're at the same time, so we could try them at the same time if they like.
All right, so if y'all want to try them at the same time, then I'll need a waiver from her on the other case as well. Donna, I know that.
She wants to do it on the 20th.
Yeah, and I come back for trouble.
You're welcome.
Thanks, Josh.
You're welcome. Have a good one.
Sure.
I mean, obviously, I think it's.
Hi there. How are you?
I'm doing great.
Good to hear.
How are you?
I just found out I'm an AFib.
Yes.
Some sort of, I had it 17 years ago. They actually stopped my heart. I was dead for 30 seconds. They started back up, had any problem, and now it's back. So,
Oh,
eh,
it's gonna be good.
yeah, it's fine.
So let me ask you this, when they stopped your heart, did you see anything?
I don't remember seeing anything,
Okay.
but they'll tell you, I had this massive burn mark right here and in my back
Oh my gosh.
when so
So they do it to stop your heart?
they stopped my heart, they reset it and they hit it again and it starts up and stayed in rhythm for 17 years. So
Oh,
big fun.
wow. So, Riot Aguilar,
I just saw him out there.
come forward.
Well, the second big songs I did today.
Hello.
Hey, Dan.
All right. Thank you for dressing appropriately for your trial.
Yes, ma'am.
Okay. Let's see if I can pull your case up. It's saying no match. All right, state,
Jason.
okay. Are you already on Riot Aguilar?
No, Your Honor, we'll be submitting our motion.
All right. And I'll await your motion.
I want object.
Okay. I've seen objections before to motions.
You want to step back? You want to? Okay.
They're doing it now.
Okay.
Well, I'm sorry to hear that, but like I say, I know everything is gonna turn out
Oh,
right.
it'll be fine. The worst part about it is my wife's not gonna be like, okay. Just,
Well, no, it's good your wife is like that because that means she cares,
oh, well,
you know?
I'm such a hypocrite. She's like, this doesn't work without you. I'm like, "Ah."
Oh, hey, that is just like from, the movie, the McGuire movie.
Yeah,
Where you had, they thought something had happened because the football player had.
right.
And she called Jerry McGuire and she's like, you don't understand, this doesn't work without him, we need him, and so.
Yeah.
It's good that your wife feels it doesn't work without you.
Yeah, well,
I used to see her all the time out at the
campaigning.
polling places, yeah, it's always nice to see
So
her.
really funny, my dad was the county commissioner here for 30+ years.
Mhm.
And when we got married, she said, if you run for anything, I'm divorcing you.
Yeah.
So
And then you're like,
Yeah.
our son will.
first time Tommy, she's all over it. She's like a duck in a June bug. She says,
Oh, yeah, I run in her at the polling places. She's always so nice.
well, thank you.
Which I always tell people, see, people can get along.
Right.
And so I would always come out there and sometimes, I'm in territory where people are like, yeah, not her. She's like, yeah, Stephanie's great. So your wife is always,
Well, thank you.
it's always fun.
Thank you.
Yes, thank you. Always.
case.
All right, thank you. Thank you. I usually run into her at Brook Hollow.
Yes. What was the guy's name? It was the House, Speaker of the House in the State House, lived over in Animal Heights. Ken, whatever it was, he was out there campaigning and he said, you need Thomas Mom's pack to win this. This is her. Her.
Oh, she is awesome. We would always take photos there.
Yeah.
We'll wait for their hand.
And she's put up with me for 40, whatever years,
How many years?
44 years.
Oh, wow. All right, we need to give her a medal
I've said that more than once.
and honor her at Commissioner's Court. All right, so what they're saying, they filed a motion to dismiss and they're saying they can't prove it beyond a reasonable doubt. Here's the thing, things happen in our life and we gotta figure out what can we learn from this. So I hope you've learned something from this. And if you have anger issues or whatever, you need to get that under control. You understand? and the complainant that's involved in this, you probably should not be around them at all. You understand?
Yes, ma'am.
So don't take this as you're going out and celebrate. You understand?
Yes, ma'am.
Take it as a learning experience.
Thank you, Your Honor.
Have a good rest of your day.
And also,
All right, just a second.
Thanks. November fifth.
Sure.
No. If you ever met his brother, right? Yeah. Guy has never had a bad day in his life. He's just happy.
All right, Travis Mann.
Good judge.
All right, so are you all ready to proceed on Mr. Mann?
Yes, Your Honor.
Yes, Judge.
All righty. Just have a seat and we'll start with the jury trial. Which case are you all proceeding on?
Judge, it would be the abatement. I mean, if you want to proceed on
Both.
both, yeah, we could proceed on both, Judge.
Okay.
That's what was my understanding.
As long as they don't object.
Camera. Camera. Oh, okay, just give me a second, I'm about to call. Okay, all right, the court is calling 2024 CR 3841, 2024 CR 3842, State versus Travis Mann. Can I have parties announced for the record for the state?
Antonio Arriola for the state.
And Mr. Mann, are you Travis Mann?
Yes, ma'am, I am.
Are both parties ready to proceed?
Is it?
State's ready.
And it's the court's understanding that defense, you're requesting that these cause numbers be tried together, is that correct?
That's very good.
State, do you have any objection to trying these cases together?
No, Your Honor.
All right, with that being said, the jury's gonna come in. How much time does each party need for your 30 minutes?
Because it's 2 counts,
30 minutes?
I was gonna ask for 40, Judge.
30 minutes?
Okay. 30 minutes?
Okay, thank you.
Okay.
All right, everyone, please be seated. Everyone, good morning. So people are acting as though they're not happy to be here. Everyone, good morning. Good morning. All right, so you're here today for a jury trial. You're in the 187th District Court. I'm Judge Stephanie Boyd, and you are on the 4th floor. So what floor are we on?
4th floor.
What's the court number? Who's the judge? Thank you. Now, you all, I know what you're probably saying. We know where we are. Why is she asking this question? The reason why I ask that question to every jury that we have up here is because sometimes we will take breaks. And when we take breaks, everyone has to leave the courtroom. And we've had situations where we've taken a break and people get lost. We've had people who've gone down and tried to get on another jury, and I've had to have the deputies go search for them. So whenever we go on a break, if you look up and everybody's gone, if you remember 187th, this is the only 187th in all of Texas. This is the only 187th in Bexar County. If you ask anybody that, they'll be able to tell you. And if all else fails, if you just remember the last name Boyd, I'm the only Boyd in the courthouse, and they'll be able to tell you where to go. So you're here for a jury trial today. It's the state of Texas versus Travis Mann. State, could you introduce yourself to the jury, please?
Good morning, I'm Tony Ariola. I'm Jason Garahan.
Good morning, Alfonso Otero, and this is my client Travis Mann.
All right, and Mr. Mann, if you could stand and introduce yourself to the jury.
Travis Mann.
All right, thank you. All right. Does anybody recognize any of those persons who have just stood before you? If you do, raise your card. All right. So in your possessions, you have cards. I always said if ever I was in a position to make somebody's job easier, I would. So we're going to make the court reporter's job easier. At least we're going to try to. I've given this instruction to every single jury that we've ever had. And we've had a lot of jury trials. Every single jury has failed this test. And I'm going to tell you what I tell each jury, but I have faith in you. So we're going to try it again to make the court reporter's job easy. Could everyone please raise your cards? Do not lower your cards until I tell you to. You're probably sitting on it. All right. So whenever you have something to say or somebody asks a question and it pertains to you, raise your card. Do not lower your card until they recognize you by number. Can everyone do that?
Yeah.
Now, in this courtroom, the sound is not great. So I'm going to tell people to lower their cards. When I call out your numbers, lower your cards. So jurors 1 through 14, lower your cards. Jurors 15 through 21, lower your cards. This is the part where juries fail, but I have faith in you all. If you still have your card up, whenever you have something to say, or if you're answering a question, I'm going to need you to stand so that the court reporter can hear. Is everyone able to do that?
Yes.
Is my faith in you misplaced?
No.
All right, thank you. You can lower your cards. All right, so in this case, Mr. Mann is charged with evading arrest detention with a vehicle and attempting to take a weapon from a peace officer. Now, what I can tell you in this case, the state and the defense will ask you questions. They are not allowed to tell you what they think the facts are of this case are. They can only speak to you in hypotheticals. So when they're talking to you, don't go in your mind and say, oh, so that's what's going on here. The only way you will know what the people think the facts of this case are is if you are actually on the jury and you hear witnesses testify. Does everyone understand? So don't go in your mind trying to figure out if, oh, this is what is happening here, because you won't know unless you're on the trial. Does everyone understand? Now, I want to talk to you about indictments. How many people here, we're going to test you with raising your cards. How many people here have ever had a traffic ticket? All right, so that continues with bad drivers being in San Antonio. You may lower your cards. All right, I've had a traffic ticket before. So let's say an officer pulls you over and they say that I'm pulling you over because you ran a stop sign. The one traffic ticket I had, it was back in the day where they had the notebook and they pull off a piece of paper and give it to you. Now I think it's some kind of electronic thing they do. When they give you that ticket, that's them saying, this is the crime I'm saying you've committed. When you accept that ticket, you're not saying, yeah, officer, you're right, I did run a stop sign. That ticket is only telling you, this is what you're being charged with, and this is where you have to appear. Does everyone understand? It's not evidence of guilt. It's not evidence of anything. An indictment is the same way. An indictment is not evidence of guilt. You can't consider it for any purpose whatsoever. The only thing and the only purpose of an indictment is to let somebody know what they're charged with and where they need to appear if they want a jury trial. Does everyone understand? Because it would be bad if somebody shows up in a criminal court and surprise, this is what you're being charged with. You want to know what you're being accused of so that you can be present and know what the case is about. Does everyone understand? So Mr. Mann here is here under indictment, but you're not to consider that as evidence or for any purpose whatsoever. Does everyone understand? If there's anyone here who cannot do that, I need you to raise your card. Now, the next thing I want to talk to you about is burden of proof and some terms that you've probably heard of if you've watched Mannix, Barnaby Jones, The Practice, those type of things. The first one is the right to remain silent. Everybody has a right to remain silent. What does that mean? You don't have to testify if you don't want to testify. I've been a defense attorney. I've been a prosecutor. There have been some times where I've had clients as a defense attorney. I'm like, you don't need to testify. The state can prove their case. What's the point? Or either I've had some clients who are just like extremely nervous, which I think everybody can understand if you're in a criminal court. Or even I've had clients that I've done municipal court work for and it's a traffic ticket. They're extremely nervous. And I'll tell them, you're just too nervous. There's no need for you to testify. And then you have some people who have speech impediments or something else that's going on and they just don't feel comfortable. The main thing that I need to let you all know is if someone decides not to testify, you cannot consider it whatsoever. You can't be like Mrs. Kravitz on Bewitched. You can't consider it at all. And I know sometimes people would say, oh, well, if that was me, I would certainly testify. Yeah, I always tell people it's easy to say that because it's not you. So if Mr. Mann decides not to testify, you cannot hold it against him. You cannot consider it. If you're deliberating, you can't be, oh, I wonder what he would have said. Does everyone understand? Is there anyone here who's going to hold it against Mr. Mann if he decides not to testify? If you feel that way, raise your card. All right, the next thing I want to talk to you is the burden of proof. Because in criminal cases, the state has to prove their case, and they have to prove their case beyond a reasonable doubt. They have to prove each element of their case. So for example, they have to prove that something happened in Bexar County. They have to prove the date it happened on, and they have to prove the elements of whatever offense someone is being charged with. Does everyone understand? Sure. Now, their burden of proof is proof beyond a reasonable doubt. When I was in law school, you had to memorize the definition for proof beyond a reasonable doubt. If you didn't know it, you felt like a failure. When I graduated from law school, my first case, I was so excited because I said the definition without stumbling. I put the comma where it should be. I paused for dramatic effect. Then guess what? After that trial, there's no longer a definition for proof beyond a reasonable doubt. I still remember it, but neither the state nor the defense can tell you what it means because we no longer have a definition. So then when I was a defense attorney and a prosecutor, I said, how best can I explain this to the jury, right? So I decided to explain it to them by telling them what it was not. So next door, you have a courthouse. It's the historic courthouse with the green rooftop. They handle civil cases. So they handle child custody cases, things involving money. They have burden of proof over there. One of their burdens of proof is preponderance of the evidence. More likely than not, something happened. So if you're ever deliberating in a criminal case and you find yourself saying, oh, is somebody's phone on? Okay. If you're ever in a criminal case and you're deliberating and you find yourself or some jury saying, well, I think more likely than not this happened, you need to stop them in their tracks because you need to tell them, nope, we're not at the historic courthouse. We're on the criminal side. That's not the burden of proof. The other burden of proof they have over there, which is their highest burden of proof, is clear and convincing evidence. Clear and convincing evidence is the type of evidence that's used to separate your legal rights from your children, which means they're saying, we think you're a danger to your child. We are not going to let you parent this child anymore, and they're terminating your rights. That's their highest burden. And I think everybody would agree that in order to take your child away from you, people had better bring a lot of evidence. Well, guess what? There's a burden that's higher than that. The highest burden we have is proof beyond a reasonable doubt. Now, both parties are going to talk to you probably and ask you questions. Can you be fair? What does fairness really mean? Sometimes people will ask you, are you going to be biased? What does that really mean? This is what this means. Nobody here was born yesterday and slept all last night. Everybody has something that has happened in their life, right? Fairness on the criminal side means this. If you are selected on this jury, whatever has transpired in your life, will you be able to just listen to whatever the facts are of this case and make a decision, if you can, on whether someone's guilty or not guilty based upon the facts that you hear in this specific case? Does everyone understand? Is there anyone who cannot do that? Now, there are two phases to a trial. People always call the first phase the innocence phase, but it's really not the innocence phase. The first phase is, did the state prove their case? Yes or no? If they prove their case, then that means that you're finding somebody guilty. If they didn't prove their case, that means you're finding somebody not guilty. And so there's no second part, no second phase. If you were to find someone guilty, then the next thing you'd have to consider is, what would the punishment be? All right, in this case, I told you there are two charges. There's attempting to take a weapon from a peace officer. That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. The other charge is evading arrest, detention with a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. In each of these cases, one of the ranges is also probation. So the question is whether or not you can consider that entire range. So let's start with the evading arrest, detention with a vehicle. The range, as I told you, you could perhaps give someone probation, 2 years, 3, 4, 5, 6, all the way up to 10. Does everyone understand the full range of punishment? Now, the question is whether or not, if you were to find someone guilty, and I'm speaking hypothetically, will you be able to listen during punishment, and whatever facts that are given you, consider the full range of punishment? I'm not saying give someone by probation, give them 2 years or 10 years, but be able to look at whatever facts that you're given and consider probation or consider 10 years. It's the same thing with the attempting to take a weapon from a peace officer, probation, or either 180 days up to 2 years in the state jail facility. And as you can see, those are wide ranges of punishment. So, for example, evading arrest, detention with a vehicle. Let me give you a hypothetical. Let's say someone is driving and they're going very fast. Let's say they ran a stop sign. They ran that stop sign, an officer gets behind them and they're trying to pull them over, but they won't stop. They're still going, speeds are reaching high numbers, right? And what the officer finds out is the person has a pregnant wife who's about to deliver, and he's rushing that person to the hospital. Guess what? That's an evading arrest, detention with the vehicle. I'm rushing because my wife is about to give birth in the back seat of the car. That's mitigation. That's okay. This is why he was rushing. Now that officer can be nice. That officer can say, oh, okay, nobody was injured. I'm not going to give you a ticket. I see what was going on. Other officer can say, hey, the law is the law. You were evading. So see you in court. Now that's a situation where people may say, this person's never been in trouble before. you know, yes, they did do this, they're guilty of it, but we're going to give them probation. You understand? Now, another hypothetical. Let's say you have someone who just robbed a bank. Of course, they're going to charge them with robbing the bank, and an officer is trying to pull them over, and they're speeding, going high rates, and the officer finally pulls them over. Guess what? They're going to be charged with robbing a bank, and they're going to be charged with evading arrest detention in a vehicle. On that case, maybe you may say, that person should get 10 years. Does everyone understand now that there are different hypotheticals where you would consider different things for different cases? So in this case, is there anyone here who cannot consider the full range of punishment? All right, the next thing I want to talk to you about is obviously this case is evading arrest detention with a vehicle and attempting to take a weapon from a peace officer. Is there anyone here who's had any bad experience with police officers or peace officers? Raise your card. All right. Number 2. Now, the next thing I want to talk to you is about the English language. I think languages are so beautiful. I wasn't supposed to be in Texas. I'm originally from Louisiana. So of course, when we had languages, I already knew that I would be retired by the time I was 21. Here I am, 23, not retired. So I took French because I knew where I was headed. It's Louisiana. We speak French, right? That would come in handy. One of my best friends in school said, Stephanie, you should take Spanish with me. And I said, when am I ever going to use this? I'm not taking Spanish, I'm taking French. So lo and behold, I ended up going to law school here, and here I am trying to learn my Spanish. But many students in my law school and in my graduate school and undergrad, they spoke so many different languages. And when you have students, international students, they speak 4 or 5 languages. One of my other best friends, he speaks 6. And I was just so, wow, this is awesome. So I can pretty much say hurry up in every language because that's what I was picking up from everybody. So is there anyone here, and raise your card if English is not your first language? Please raise your card. All right, and make sure your cards are turned around so I can see your number. 14, 23, I'm sorry, 21, 23, 25, 34, 35, 51, 53, and 72. Number 14, what's your first language? Oh, this is the first Russian we've had. How do you say hurry up in Russian? And to the court reporter, you don't have to take that answer down.
Focus.
Okay, doesn't that sound great, right? Like, hey, he's serious. All right, have you been able to understand everything?
Yes, ma'am.
All right, thank you. 21, what's your first language? And please stand. Oh,
Spanish.
Spanish. All right. Have you been able to understand everything?
Yes, ma'am.
All right, thank you. 23. What's your first language?
Spanish.
Have you been able to understand everything?
So far, yes.
All right, thank you. 25.
Tagalog.
Is that Philippines?
Yes.
Yes, I know how to say hurry up in your language because I've had it said to me. Have you been able to understand everything?
Yes.
Thank you. 34.
Spanish.
Have you been able to understand everything? Thank you. 35.
Spanish, and I understood everything.
Thank you. 51.
Spanish.
And have you been able to understand everything? Thank you. 53.
Spanish as well.
Have you been able to understand everything?
Yes, ma'am.
72.
Spanish.
Have you been able to understand everything? Thank you. All right, you guys are following the rules great. My faith has been, greatly placed. All right, next thing I want to talk to you all about is travel arrangements. I do not expect this case to go into the Thanksgiving holidays or anything of that nature, but is there anyone who has time constraints, travel arrangements, you have non-refundable tickets, please raise your card. All right, 32, 37, 42, 44, and 63. Number 32, what is your time constraint?
It's gonna be after Thanksgiving, but just
holidays.
All right. All right, thank you. 37?
My time constraint is mostly the fact that
I'm sorry, what?
my time constraint is mostly that I don't have a vehicle, and it took me about 15 minutes to Uber here. And
Oh.
bus is also only about an hour.
All right, thank you. 42?
I'm going to Houston tomorrow.
What are you doing in Houston?
I'm going visiting family for the weekend. Ready for tickets.
Well, how's that gonna play? Doesn't Texas play over the weekend?
We'll see how it goes.
All right. Number 44?
11:22 to 11:29.
I'm sorry, the first date?
11:22.
And what are you doing?
Heading to Seattle.
What are you doing in Seattle?
Visiting family.
All right, thank you. 63?
Going to Arkansas
When?
Wednesdays, next Wednesday.
Next Wednesday? All right, thank you. All right, so I'm gonna tell you all two stories. Both of these stories are true. I understand that jury duty is an inconvenience, and I call it an inconvenience because one, you have to pay for parking. And even though they validate your parking, it's sort of like, why do we have to pay for parking? We're doing you a favor. And then when you come downtown, you don't know where to go. There's so many one ways, and you're like, if I could just turn right here, I finally found it. And you can't because it's one way. And then I see you all rushing over to get here at 8 a.m. And then you understand it's hurry up and wait. So I always say that it's an inconvenience, but your country only asks two things of you. They ask for you to pay your taxes, and they ask for you to serve on a jury duty. And they don't even call you up every month. It's probably once in a blue moon. This is what I call a sacrifice. My family grew up in a small town called Grand Canyon, Louisiana. My uncle was super smart, and all the teachers knew all the students. And so when a teacher felt like they taught him everything they could teach him, they would just move him to the next grade. They would tell my grandmother, Miss Lang, there's nothing else we can teach him. He's super smart. And they would just move him to the next grade. So of course, his brother and his sisters, when they came up behind him, they didn't like that so much because the teachers would be like, we're expecting a lot out of you because your brother's super smart. Well, he ends up graduating from high school and the Vietnam War breaks out. He goes to my grandmother and he says, they're already drafting everyone here. I need you to sign so I can go because this is the only way I'm going to prove my lot in life. And I say that as a sacrifice because my grandmother signed for him to go. And for young people, there was no 24-hour television station. You had 3 channels, ABC, CBS, NBC, and NBC wasn't very dependable. And when your television cut off, sometimes it would just be white noise. Sometimes they play the national anthem and the flag would just be blowing on the screen. And then you wait for the next day for programming to start. Nobody knew where Vietnam was. Nobody knew what was going on. My grandmother's phone wasn't a touch tone. There wasn't a rotary. I know young people don't know what a touch tone or a rotary is, but how she made phone calls is you pick up the phone, and when you pick it up, an operator answers and you tell them what number you want to dial. That's why you had songs like Beechwood 45789, because you just pick it up and you dial it. So my grandmother, all she had was his number, his number for the military, and you just send it and you put Vietnam on it and hopefully it comes back. My grandmother had a 6th grade education, but she was super intelligent. She taught me my ABCs, how to tell time and how to read when she would babysit me. One thing that she did quickly discover is that you did not want the military knocking on your door because one or two things happen. Either somebody died or either someone's badly injured. So I consider that to be a sacrifice. So when you think what your country is asking for you, they don't have the draft anymore. They're not asking you to serve. They're just asking you to do jury duty and pay your taxes. The second story I want to tell you is about one of my friends. We went to law school together. She decided to do civil law. I always wanted to do criminal law. This has always been my passion. She called me one day and she said she had jury duty. Let's meet for lunch. I'm like, great. We haven't seen each other for a while. So we meet for lunch and I ask her, how is jury duty coming along? And she tells me it's coming along and it's fabulous. Now I'm thinking, how could it have been fabulous? You're not with Stephanie Boyd. What's happening? And so she tells me, I'm not going to be selected. And I said, what do you mean? She's like, it's like when I was in law school. I'm on the back row. I'm keeping my head down. I'm not saying anything. I started laughing. She said, what's so funny? I said, you so are going to be on that jury. And she was, and we got to have lunch the entire week. So it was good times for everyone. So I tell you that story to tell you that one, the best way to be on this jury, other than raising a sign saying, please place me on this jury, is not to say anything at all. All right. So the defense and the state are going to have 30 minutes to speak to you. So just give them your attention. And if anybody ever needs a break, just do the break sign and I will recognize you. All right, state, are you ready?
Yes, Your Honor.
All right, you may proceed.
Thank you. Seven. Good morning. As the judge said, we got about 30 minutes. So what I want to do is quickly go over some of the points that she's already made. Remind you about that, and then also go over some new information that you haven't heard, which is the law that you're going to hear at the end of this trial, as well as some other issues that might come up during the trial. So as Judge Boyd explained, this is a case against the defendant, Travis Mann. And so, again, the ground rules. There's 75 of you in this room. Both myself, Jason, and defense attorney, Mr. Otero, we're going to choose 12 of you to be on our jury. And so we can't bring up the facts in this case. We'd like for you to answer the questions honestly. And last, participation is important. So I'm not going to philosophize too much, but I do want to say this. Your participation in this process is critical for our legal system. Why is that? Well, if you believe that the legal system is doing a good job, then we want you to be on this jury to make sure that it continues to do a good job. If you think it needs improvement, well, we want you on this jury so you can, with your voice, improve the system. Or if you think it's not doing a good job, we also want you on this jury so you can improve the system. So the first charge against Mr. Mann, evading arrest or detention with a vehicle. And so what we're going to have to prove to you by the end of the trial are the following points, or we call them elements. So with our witnesses, we need to prove that it's Mr. Mann on or about a certain day, that here in Bexar County, he intentionally flees from a person he knows is a peace officer. And the peace officer is attempting lawfully to arrest or detain him. And last, he used the vehicle while the actor is in flight. So first, I want to draw your attention to intentionally. I'll explain the legal definition. How we prove in these cases that he knows that the other person is a peace officer. So first with intentionally. So the legal definition of intentionally, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. So let me start out by asking a question. I'll start with juror number 1. How can you tell someone's intent? What things do you look for? Body language. Okay. I like that. Juror number 2. Actions. Perfect. Juror number 3. Anything else? Okay. Juror number 4. Actions. Yeah, I think you guys are on the right track, right? What do we look for? You observe their behavior, right? Their body language. Listen to the words. Maybe they tell you what their intent is. And then really you just consider the circumstances of the event. And then you can decide whether their actions formed a certain intent. I have an example to show you. So intentionally. let's say I live at the Pearl, picture of the Pearl. I have an apartment with the balcony that leads to the area where they have a little farmer's market. Went to bed late, trying to sleep in. Loud crowd noise wakes me up. I'm upset. So what I do is I go grab a bowling ball, go up to the balcony. I don't like the person at the bottom of the picture in the orange shirt, right? I aim for him, throw the bowling ball towards him, and it hits him, right? So here, based on my aim, based on my desire to hit the person in the orange shirt at the bottom of the picture, well, there I intentionally hit him with the bowling ball. Juror number 5. How do we know if someone is a police officer? Okay. Juror number 6.
Uniform?
Uniform, exactly. Juror number 7. Badge. Okay. Juror number 8. All the above. Maybe they even tell you, hey, I'm with such and such police department, right? So yeah, again, you guys are on the right track. Maybe they're driving a police vehicle that's got the markings on the outside. They're wearing the uniform. They're wearing the badge. They could tell you they're an officer. Now, juror number 9. How do you know when a police officer is either trying to stop you? We call that detaining you or trying to arrest you. Okay. And so what do the lights mean when the officer has the lights on? Stop. Okay, exactly. They're gonna have the sirens, they're gonna have maybe the, I don't know what to call it, the whoop whoop sound, right? From the car that they're trying to get your attention. Maybe they even get on their microphone and they tell you to pull over. So the second charge against Mr. Mann, attempting to take a weapon from a peace officer. So here, by the end of the trial, we need to prove to you that Mr. Mann, on or about a certain date in Bexar County, Texas, intentionally or knowingly and with force, attempts to take from a peace officer any of the following. And in a minute, I want to talk about knowingly, because we haven't seen that up until this point. Could be trying to attempt to take their firearm, their nightstick, stun gun, or a personal protection chemical dispensing device, right? Their pepper spray, their mace spray. So again, just to remind you, the definition of intentionally, person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. But now we have the definition for knowingly. So a person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. So again, he's aware that his conduct is reasonably certain to cause the result. So going back to the Pearl farmers market example, let's say same set of circumstances. I'm annoyed. They woke me up. Go out to my balcony. I've got the bowling ball. But this time, I'm not aiming for a specific person below me, right? I just see the crowd below my balcony. I know there's 30 people out in front of me under the balcony. I just toss the bowling ball right above them, and it ends up striking one of the people in the crowd. So there, it is in my intent to hit a specific person. But I see the crowd below my balcony. I am aware that, hey, if I drop this bowling ball over them, right, it's reasonably certain that it's going to hit one of them on the head. So that's the difference between when you intend to do something, you're like intending to hit someone with a bowling ball, versus knowingly hitting someone in the crowd with the bowling ball. And of course, with our witnesses, with all our evidence, we have to prove to you that Mr. Mann committed these crimes beyond a reasonable doubt. The judge explained there's no definition we can give you. And simply it's because our highest court has said people know what the word reasonable means. You don't have to define it for them. But again, I can tell you what it is not. right? It's not 100% certainty. Because let's think about that for a second. Juror number 10. You can be 100% certain something did or didn't happen. What would that mean? Okay. So with your background, you're under absolutes. But for you to say, hey, I know for a fact 100% that this happened or this didn't happen.
Saw and understood the process of their mind.
Right. And since you're not one of the witnesses in this case, 100%, exactly. It's not beyond, I know back in the 40s and 50s, some of these TV shows would say a shadow of a doubt. It's not beyond a shadow of a doubt. For juror number 10, it's not a specific percentage, right? Beyond a certain percentage confidence level. But I think the best way for me to explain this is, let's say, the beginning of the trial. I want to see who here knows a lot of landmarks in the US or has traveled a lot. Juror number 24? Okay. Well, I want you to pay attention, but also anyone else here, let's see who can identify this famous landmark in the US. And please let me know once, speak out loud once you've identified it. We've got one puzzle piece. Two. Anybody? No. Three. Juror number 4?
Mount Rushmore?
Mount Rushmore. Okay. So that's probably the quickest I've ever had someone identify it. It is Mount Rushmore. You've only seen 3 pieces. Are you confident it's Mount Rushmore? So what made you say it was Mount Rushmore? You've seen it before. Do you have any doubts that it's not Mount Rushmore? Okay. Someone else raise their card. Are you gonna guess the same thing?
Yes.
Okay. So here, juror number 4, juror number 14, why are you confident that it's Mount Rushmore? Okay. So with your life experience, you're able to say it with 3 puzzle pieces, it's Mount Rushmore. What about juror number 7? Are you able to say the same thing?
All right, everyone, remember to keep your voice up so the court reporter can hear.
Sorry.
With 3 puzzle pieces, are you saying it's Mount Rushmore?
Yes.
Okay. Anyone here who says that's not enough for me? I need to see more. Okay, that makes perfect sense, right? It's only 3 pieces. So that's what reasonable doubt is, right? It might mean something to juror number 4, juror number 14. They with 3 pieces, and juror number 7, they can say it's Mount Rushmore. The rest of you want to see more, right? Before you can say, okay, beyond a reasonable doubt, this is in fact, and we'll skip ahead. Mount Rushmore. Let me give you an example. Juror number 12 or 11. Yeah, I don't skip you. Let's say last night you're shopping at HEB. You're walking to your car, pushing your shopping cart to the car. Someone comes up to you, points a gun at you, demands your wallet. Of course, you give them the wallet. Then you run back into the store, call police, make a report. They are able to catch the guy down the road, rob you. Now let's say further down the line, there's now a robbery case against them. You're called as a witness. You come into a courtroom like this one, and you testify about what happened to you that night. Is your testimony evident? You're telling the jury, this is what happened to me. So it's not just sort of, it's wanted to make it clear to the group. So you as a witness and your testimony about what you saw, that is evidence. So if anyone can repeat after me, testimony is evidence.
Testimony is evidence.
Ultimately, why are you guys here? You guys are the judges of the evidence, okay? You're going to decide how much weight to apply to each fact or piece of evidence that you hear or see in this courtroom. And you get to watch the witnesses on the stand and decide whether you believe them, right? And when I say whether you believe them, maybe you say, I think they're telling me the truth. Maybe you say, I don't believe them at all. Or maybe you say, I think they're kind of telling me the truth. These couple of points didn't really make sense to me, but I think we're kind of getting the truth from them. You decide how much weight you want to put to any testimony or piece of evidence. And last, you get to draw reasonable inferences from the testimony and from the facts. Next, quickly, Mr. Mann has a Fifth Amendment right. He doesn't have to testify if he doesn't want to. And you're not able to use that against him, right? Or use that as any kind of evidence in this case. But if he does choose to testify, I just wanted to say this, you should judge his credibility like any witness. And because he's like any other witness, there are no brownie points for testifying. Again, there's going to be might be some doubts about things in this trial. And unfortunately, a trial is not designed to show you the complete picture about what happened. Why I say that? You may never learn things like motive, the defendant's motive to commit the crime. And when you think about it, that's because it's in his mind, right? His decision to commit the crime or not commit the crime, his decision to act the way he did, right? That's in his head. Sometimes it comes out with our witnesses, with our evidence, sometimes it doesn't. But if for some reason motive does not come out in this trial, it's not one of the elements that we have to prove to you that a crime was committed. As you can expect, there are going to be police witnesses in this case. And I just wanted to say they should be treated like any other witness. So when I say that, they may come in with a uniform, they may come in wearing a badge. You shouldn't give them more points because they're a police officer. They should be at the same level as any other witness. But you are able to hear and consider their experience, right, when judging their credibility. And so here I just wanted to ask again, I know only one person raised their card, juror number 2. Anyone here had a bad experience with police? Juror number, start with 6. Remember what agency it was, what police department?
Well, it wasn't directly with me. My younger brother was, San Antonio PD. I say a bad experience because it ultimately is affecting my entire family. My younger brother's in a wheelchair now because of it.
Very sorry to hear that. I'll tell you this case does not involve SAPD. Now, if you're on this jury, are you going to be able to set aside that experience
Absolutely.
with SAPD
Absolutely.
and wait to hear from the officers in this case?
Absolutely. My older brother was a police officer back in El Paso, so I still have a lot of respect for law enforcement.
Okay. I think I saw someone over here. Juror number 37.
Yeah, my father is just much Hispanic, and I've been with him multiple times on different occasions where police officers have arrested.
Okay, I'm so sorry. People are having problems hearing.
My father is Hispanic and appears a lot more so than I do. And multiple times I have been with him when he's been harassed by law enforcement.
And has that happened here in San Antonio?
San Antonio, a couple times. At the beach, I cannot remember the name of it. In the state. A couple of times outside the state of Colorado.
Well, I'm very sorry to hear that. Obviously, that's not something that anyone should go through. Now, knowing that that's happened to your father, if you're on this jury, are you going to be able to set aside those experiences?
To the best of my ability.
Okay. And you're jury number 37, right? Thank you. Jury number 22.
Yeah, I had a bad experience.
Do you remember what police department it was?
SAPD. But it saved my life.
So it was a bad experience, but it saved your life.
It really did. I'm just saying right out. 3 days before, I got
I guess a warning that I was gonna get electrocuted. In leveling a house, everybody got electrocuted under there. I got tased 6 times. So I ended up police department afterwards. And I didn't die under that house. I know it sounds funny, but it's the truth. So I did get electrocuted. But it saved my life because I was on my way back to that house to go under. I had a big leak, electrical was all over the place. And people got electrocuted under it. After I went, got arrested, got put there, then I ended up at Whataburger that evening. Didn't end up in the morgue. If I was gone under that house. So it did save my life. And I'm just saying it because, hey, God's real. And hey, I got a warning 3 days before somebody had a dream. They told me you're gonna get electrocuted. It happened.
Wow.
Hey, I'm gonna be honest. I'm gonna just say it. Could have stayed quiet and kept it.
No, thank you for sharing.
Yeah.
Anybody else?
But I hold nothing against.
Okay. No, thank you, juror number 22. Anybody, juror number 35?
I don't understand clearly the question of what is bad. I mean, I've had several experiences. I'm a civil rights attorney, and I've had several experiences where I've had to coach and counsel and correct police officers. If I see something, I say something. One example was a young woman who worked for me, who was a Black female attorney, died. At the funeral, we were going from the church to the cemetery. And we went through the light because that's what happens when you're going from the church to the cemetery. We were escorted by motorcycle officers. Not breaking any law, but when the officers were out of sight, an unmarked police car pulled over the car in front of me and berated him for running a red light. Not wearing a uniform, not showing a badge. And when I stepped out and said, "What are you doing? Do you realize you've stopped the funeral procession?" And then he finally looked both ways and realized he stopped the funeral procession. He was white, the funeral procession was black. So I corrected him. So to me, that was a bad experience. If you use my definition, what's bad? The result was he ran away, jumped into the car, never identified himself. And I can give other examples, but that's the one I chose.
Do you remember what police agency that was?
Washington, DC.
Okay.
But I've also corrected an officer south of Corpus Christi. He was pulling over women and he was putting the move on them. And I asked him why he stopped me, and he said, "Well, you have the wrong kind of frame around your license plate in the back." And I said, "Where?" And he said, this plastic one. And then I pulled it away from the vehicle and broke the frame. And I said, "Are we okay now?" And that corrected him. And he let me go. But I found out he had been harassing people in that same area.
And that was also in DC?
That was south of Corpus Christi.
Okay.
And the closest one to San Antonio is the Selma famous stop, where if you're driving at night, the Selma police will pull you over and tell you that you're speeding. And I was able to explain to him that I'm a law professor and I just finished teaching a night class and I was not speeding. And he understood that I was not sleepy. I was not under the influence of drugs. I was managing my vehicle, and he didn't give me his name.
That guy was with Selma?
Yep, just a
Okay.
few miles from here. That's it.
Let me ask you this, Ms. Juror number 35. There are going to be officers that come in as witnesses. Are those personal experiences you've had with police officers gonna affect or shape
I will
the
leave
way
it to
you see
you
these
attorneys and to
witnesses?
the judge to correct them if they make a misstatement or if they try to take advantage of how polite you are being.
Could you say that first part? I didn't hear you.
I will leave it to the attorneys here and to the judge to make what corrections similar to how I made. I address the problem when I see the problem.
Okay.
And I would trust you all that you would do the same thing.
And you, as far as a juror, let's say you're a jury in this case, and you're sitting here in the jury box. Is that going to affect the way you hear the testimony from these officers?
I understand the judge's instructions to only use the experiences and the information that is presented in this trial. But you asked, have I had a bad experience with police?
Mm.
And I'm answered truthfully.
Okay, thank you. Anybody else? Juror number 70?
Actually opposite. I actually work as a crime scene investigator for San Antonio Police.
Okay,
So I would like to say that I wouldn't be biased, but I'm gonna be honest, I have gone to places where there are OISs. I've seen evidence and actually processed the evidence. So I believe I would have bias on this case.
you're biased.
Oh, sorry, just 1 second. All right, if we could have a pause, the juror needs a break.
Okay.
So I'm going to pause your time, counsel. All right, ladies and gentlemen, we're going to take a break. And I'm going to have you all back here at 12:15. If you're looking for a restroom, wherever you see a stairwell, there's a restroom on either side. So please leave your cards behind. And then make sure, wait, everybody's anxious. Look to your left, look to your right. That's the person you're responsible for. So make sure that
You have
you
no
lined
rights
up
to that.
outside, all right? All right, everyone, please rise for the jurors.
You're not gonna be Everybody has.
Yeah, it's right here.
All right, let's bring them in.
Predator.
Deputy Lord, they're ready?
No, they're putting minority judge.
Okay. And then what we'll do, everyone, we'll have both sides finish their voir dire. Then I'm gonna send them on a lunch break. Y'all can do your strikes. And then depending on when we finish this, I'll tell you all when to come back as far as, you know, have your witnesses here for testimony. So we should be able to get some testimony in.
Okay. We're gonna only probably have max 2 witnesses.
Oh, well, we'll talk about that after we do jury selection. Okay.
Freezes up.
I wanted to play this.
I think it's gotten worse since Odyssey. Oh, yeah, definitely.
61, Judge.
Ah,
It was number 61. All right, thank you. It's easier the second time around. You made it back, Judge.
all right, thank you. All right, everyone, please be seated. All right, so ladies and gentlemen, the state is going to continue with their voir dire, but before I turn it back over to them, I just want to let you know that sometimes attorneys have to be in many courts. But in this case, Mr. Otero is actually the first chair attorney on this case. So he's had a second chair join him as well. If you'll introduce yourself to the people, please.
Hello, everybody. My name is Juan Gonzalez.
All right, does anyone recognize him? If you do, please raise your card. All right, you may be seated. State you may continue.
Thank you, Your Honor. I only have a few more minutes. I think before we left off for the break, was it juror number 70? You were saying that you've had positive experiences with police?
Well, I mean, I've seen what happens when people don't or listen to police, I go and process officer involved shootings, people who use of force. I see this, and also testify on this.
Okay. And so if I wrote it down correctly, because of what you do in these investigations, you think you have a bias? Okay. Thank you, juror number 70. Two more slides. Has anyone here served either on a criminal or a civil jury? So starting with this section, juror number 6 and juror number 8. Okay. Was it criminal or civil?
Civil.
Okay. And juror number 8? Okay. Did you guys reach a verdict?
Yes.
And was the punishment judge or jury? Okay. Would you say you had a good or a bad experience? Okay. In this section, juror number 23, civil, okay. Juror number 24,
Civil.
okay. Juror number 45,
Case.
okay, was that here in Bear County? Did you guys reach a verdict?
Yeah.
Okay. Was punishment to the judge or the jury?
Judge.
Okay. And over here, juror number 55,
Civil.
okay, thank you. And juror number 62? Okay, thank you. And then last, just to remind you, because the judge touched on this, the punishment, if we do, if you guys do think that Mr. Mann is guilty, you guys will be deciding punishment in this case. And so for evading arrest or detention with a vehicle. That's a third-degree felony. Punishment range is 2 to 10 years in prison or eligible for probation. The second one, attempting to take a weapon from a peace officer, that's a state jail felony. That's below a third degree. The punishment range is 180 days to 2 years, or also eligible for probation. I just wanted to ask, can everyone here keep an open mind to the full punishment range until you hear the evidence in this case?
Yes, sir.
All right. Thank you for your time.
All right, defense? Yes.
Council, good morning.
Morning.
Actually, good afternoon. Yes, as I told you before, my name is Alfonso Otero. And I'm glad to hear that I'm not the only one here with Spanish as my first language. So if anything, you don't understand what I'm saying, I really appreciate if you call on me and say, you know what? I don't know what you're saying. Can you repeat it? Repeat it. Can you use your lawyer English? That's what my girlfriend said. And so we start here. This is a very important part on our criminal process. And this is because it's the only time we have to know each other. This is the only time we know and we have that we can speak directly to each other and we can look at people and see if you are actually a good juror. A good juror means that you're gonna sit here, you're gonna see the evidence from the stand, and you're not gonna let any bias interfere on your judgment. Oh, these are wrong ones. There you go. I go, oh, forward. There you go. Yeah. There you go. So there's some cases that we know, like for example, in civil cases that the judges have reviewed the facts of the case. And after that, they decide that they can go to the jury, right? Does anybody here think that the judge knows any fact about this case? Just raise your number if you do. Okay, number 6? Is that yes? Yes. And what do you think that the judge knows?
Well, Judge, I think obviously knows, obviously more than what we do right now, and she feels it
Okay,
has enough evidence to move to a jury trial.
but that's a good question, because would it surprise you that the judge has no idea what the facts of this case are? Yeah, so the judge today has no idea what the case is all about, has not reviewed any facts, right? And probably knows less than you and the prosecutors and us. We're just here to be like a gatekeeper of the evidence. So no, the judge has not reviewed the case. This case has not been vetted by anyone. This is fresh start. Nobody knows but the prosecutors and us. Now, we were talking about what the fair trial is. And the fair trial is guaranteed by the Sixth Amendment. And that's the guarantee of a jury of your peers that has no bias against you. They're gonna sit there, gonna see the facts, and they're going to judge the credibility of the witnesses, and they're gonna be fair and impartial. So this is very important because every time we have a jury trial, some people say, you know what, I need to hear from him in order to make an intelligent decision. I need to make a sound decision, and I need to hear his part, right? Because common sense says, you know, you're accused of a crime. You are the first one out the door saying, I didn't do it, right? So in this case, does anybody expect or Mr. Travis to stand up and testify on his behalf? Any shows of hands? Nobody? Okay. So do you think, I think we pulled that right. So we need to get it right. And now this is when it gets a little complicated, right? Anybody here, what do you think that the government needs to do as far as investigations and things to bring charges against us, against somebody? Juror number 15,
Evidence?
evidence, right? And what do you think they need to bring evidence? What kind of evidence do you expect them to bring?
Well, it depends on the.
Can you stand up and speak? Sorry.
It depends on the situation.
Right.
So whether it's witnesses or just in materials, paperwork, etc. Pictures,
Okay. Videos?
videos.
Okay. And so this is very important, right? Because when we are sitting here, or when Mr. Travis is sitting here, his life is at stake, right? This is a felony. If he gets convicted, he's gonna keep for life a pen of a felon. And so it's fair that the police, the district attorneys, and everybody else do their job. And they need to do it thoroughly, right? Does anybody disagree with that? So we were talking about evidence, right? And so some of the items that sometimes come into evidence are documents, videos, recording, testimony, photographs. Now, I'm going to tell you one thing. You're going to hear a lot about reports, right? But you're not going to get to see it. The reports, they don't go to the jury, okay? And so we need to be aware of that. And is there anybody who would say, you know what, we didn't get the report because the defense didn't want to see us, what is in it? Anybody here? All right. Now we go to witness credibility. And this is very important, right? How do we determine somebody is telling us the truth? Juror number 21.
I guess based on past experiences or credibility for their jobs or what they've done in the past.
Right. Like let's say an example, somebody said something before and they changed their.
Right, yeah, if they, yeah, exactly, if they've changed their mind in previous cases or. Yeah.
Okay, juror number 18.
I'm sorry, how do we determine if they're credible?
Yeah.
Based on their experience, based on what they saw, to his word on their jobs, if they're professionals in their jobs, depending on what they're giving their testimony on.
Right. How about their own experiences, right? Sometimes we are acting in the heat of the moment, right? All these things happen in seconds or even faster. So perception is another thing, right? So one of those things is, like circumstances, location, the level of stress of the people. Sometimes we perceive things more as a threat as they really are. And that's because of the stress. Anybody agrees with that? All right. Now, here we have some people who have bad experiences or good experiences with law enforcement. Do you think that an officer, anybody here thinks that an officer, just because wears a badge and has been trained in policing, his word is worth it more than a regular person? Anybody here? Number 20. Can you tell us why?
Never experienced bad experience with police officers. Yes, I got pulled over a few times, speeding, whatever. But my experience with what happened, I have 5 children, 3 young men, and I have to literally tell them how to act every day because of the color of their skin. So a lot of times the officers get right because there's no videos, there's no pictures, there's no witness. And that person who was pulled over, hopefully they were doing the right thing on the police officer's side. We know what happened in 2020. So I don't have the confidence.
Right.
that they would say the right thing, because if there's no evidence to prove it. I
Sorry.
think there should be videos, pictures, and everything to prove what that officer is saying, correct? And on the other side.
So would you say that an officer has the same credibility as anybody else in
They
the
should.
city?
They should.
Is that the case with you?
I don't know if I feel that comfortable with that,
Okay.
okay? But
And,
they should. We all should be treated equal. It does not happen.
And knowing that and having that feeling, would that sway you in any way? Would you say that you cannot refer to the state?
I wouldn't say yes to that, but I would have to hear it to know, to make that decision. I would not try to judge prior, but my gut feeling is not comfortable for me because of history of incidents that happen in our
And
lives.
correct me if I'm wrong. What you're saying is that to make a fair decision, you need to hear the evidence and weigh it yourself. But without that, you're fine.
Yes, sir. Yes, sir.
Thank you. Anybody, I saw another number somewhere in the back. 26.
I think officers' testimony should have a higher weight because they have another oath that they have to take to be an officer.
So you said that in your mind, an officer is more credible because he's taken a note and has some training, and that's his job.
Right.
And knowing that, would you give him more credibility to the police than to anybody else?
Yes.
And that would, in other words, you would be biased against the defendant because of that more credibility toward the officer, right? 55.
I don't know if it's a matter of trustworthiness or not, but certainly professionally experienced, informed, I would give them that that's something that they would know more about than the average.
Okay.
Stay calm under the circumstances, procedurally, what's supposed to happen, and so on.
And so saying that, would you agree with the prior juror that you would give more credibility to the officer than anybody other lay witnesses?
It would depend on what their evidence was.
Right, but just talking about,
Depend on what their testimony.
yeah, but just talking about credibility. Both sides say one thing, the other say completely opposite. And having that, would you give more credibility to the officer because he's an officer? And so would it be fair that that makes you biased against the defendant?
Potentially so.
Thank you. Anybody else? Did I see any parts? Okay, now we all know the officers make mistakes, right? They're human beings. And sometimes, they're zealously advocating or doing their job, trying to prevent. Obviously, they're here to protect all of us. But sometimes they misstep, right? Sometimes their desire to protect other people have them making mistakes of what they see, what they perceive. Anybody here agrees with that? Anybody disagrees? Now, this is an important thing, objections. We have a couple lawyers in the panel today. 35. Can you tell us what is an objection?
An objection based on law is the lawyer asking for the judge's attention to make a ruling on whether something inappropriate is going to be presented to the jury or not. There are other kinds of religious objections and political objections and all kinds of things that shouldn't be affecting what the jurors do.
Okay, thank you. So sometimes it's my experience that after jury trials, jurors tell me that objections, they think that we're doing something to prevent the juror to listen to some evidence, like we're hiding something. Anybody feels that way? Okay, and so objections are made so something that is not legally admissible in evidence doesn't get to the jury. And so that ensures that everybody has a fair trial. Anybody that? Now, bias. And this is very important. And I think this is the most important thing. any jury trial. How many of you think that the dog is gonna have a fair trial there? Right, and so that's exactly what we're trying to prevent. There's no easy cases to judge, right? And it's not easy because we are all human, right? We all have our experiences, our ideology, our biases. We have all these things. And what is an implicit bias or unconscious bias? Anybody that wants to volunteer? I see that there's a psychologist in the panel somewhere. Yeah. What?
For the psychologist?
Yes.
That's me.
Oh, okay. So I'm sure you're more versed about this, that if you can stand up and tell what you think of bias, implicit, or any other biases.
Biases are gonna come from the individual's upbringing, their experience through life, through their families, through their friends, through schooling, through religion, and so forth. And it provides sort of a framework for how they look at the world based on all the inputs that have led to their development. And that would naturally potentially have an influence on how they perceive things.
And make a decision, right? Okay, thank you. You did it better than me. And so everything could be biased, right? And people are biased against cars, and people are biased against burglaries. People are biased against tall people, short people, any kind of biases, they all exist. But let me tell you, this is not a character flaw. This is something natural that we all have. And we need to go through it. And while we're sitting here, we need to do a soul search internal into us. Because it's Travis' life here that we're talking about. And so we need to come in with a clean slate, sit down there, having no bias against it, right? It doesn't mean that you're right or you're wrong. It just doesn't mean that some people have different feelings about something else or other things. Let's see you kind of, you're number 16. Do you have a question or? No? And so decision making, it has a lot of hard choices because they have life lasting consequences to people. Now, this is a very good point. And let's think about, for example, juror number 55. He explained what biases are, right? He also told that he's not offense or anything, it's just not picking on you, that would give more credibility to the officer than to a lay witness, right? And so most of us would say, well, you know what? I find it hard to believe a police officer or backwards, right? And that is because, as we heard before from people in the panels, that they had bad experiences with them. And that creates that bias and that makes them think and react different than other people. They get triggered in other words. And so anybody here, you're 36. Do you think that if you have a bias and that, I'm sorry, can you stand up? And that alarm goes and rings in your head about that specific bias. Do you think you can check it out and unring it? Probably. You think you can do that?
Yeah.
How would you exactly do that?
I have a question for you, if you don't
Yes.
mind. When you're speaking of police officers, are you speaking in police officer in general or in this particular case?
It's just in general.
Okay.
Yeah, but I cannot tell you anything about facts of this case. It's in general.
I see.
Yeah. So do you think you can ring that alarm and just keep it away?
Okay.
That's, I mean, we need to know, like, yeah, no, and then,
Hard to say.
it is hard to say, but let's say that you don't like chocolate milk. Can you take that taste out of your mouth and say, no, now I'm gonna follow the direction I want to drink the chocolate milk?
Oh, you're trained for chocolate milk to be tough.
Exactly, right? Same thing with the biases.
Yes.
So do you agree with me that you cannot uncheck that alarm?
Right. I guess so.
Is that yes?
Yes, yes.
Anybody else here feeling differently? Okay, now this is very important because the burden of proof rests on the prosecutors. Mr. Mann can just stay there all day. Don't say anything. Don't do anything. We can just sit here, do nothing. And it never goes to us. Never. So does anybody here? Juror 38. Do you, in this case, would you expect us to prove that Mr. Mann is not guilty?
You're the defense, yes, I would assume that you would do with all of your power to get him the verdict he wants.
So that you expect him to bring witnesses on his behalf and do all the same?
I would hope so.
Yeah, and if he doesn't, I'm sorry,
To
go ahead.
establish credibility or witnesses or whatever, so that way you can swing the jurors in on your side.
Okay. And so if that expectation of you, if we don't bring any witnesses, would you be still able to find him not guilty?
No, because I'm assuming the state has video or whatever presentable from their clock cars or their cams or any form of paperwork. But I would not, well, I guess upon hearing everything at the end, I would just have to make decisions based on what I've heard. So if your offensive, your state doesn't present a good case, then I guess I would be able to give him not guilty verdict.
Right, but would you require him to put evidence on his behalf?
For me, yes, that would need to be something there for me to decide that way.
And so is it fair to say that because you expect him to put evidence on his behalf, you would, if he doesn't, you would be, in other words, you would you be prejudiced against him because he's not putting anything?
Prejudice, I don't really like that word, but I guess, yes, I would be.
Thank you.
Uh-huh.
Anybody else feels the same?
And I'm sorry, what was the number?
Mine, 38.
All right.
Oh, 44?
Yeah, I mean, I agree with her. I think if there was evidence that was gonna support a not guilty based on the defense, then I think that I would agree. I don't know that I would be prejudiced, but I think it would be difficult for me to say that he wasn't guilty if nothing was presented to back that up, especially if the evidence from what the police have were to say otherwise.
Right, so you require him to prove something.
Yes.
Okay, thank you. 51?
Yeah, I mean, I agree with them.
Say?
I don't see like any evidence of, like, sorry to like to know that he's not guilty.
Yeah, no, thank you. And I really appreciate that. This is one of the best finals I've ever had.
All right, and just, let me just pause you for one moment. So I want to make sure that everybody understands what the law is. And let me tell you what the law is. Defense does not have to prove anything. And it's partially my fault because I forgot to tell you this in the beginning. When we're in law school, you know what our professors told us we needed to do as a defense attorney? They said you could sit over here and play crosswords, go to sleep, do nothing. And the reason why you can do that is because you don't have the burden. You don't have to prove anything. The state has to prove their case beyond a reasonable doubt. Think of the state's proof. Think of it as some rocks on their table or a cell phone. The defense never has to go over there and pick up that cell phone. It's always with the state. The state has to prove their case beyond a reasonable doubt. And do I expect them to be doing crosswords, puzzle, or reading comics? No, I've never seen an attorney do that. But the reason why that is said is because they don't have to prove anything. Nobody forces you to come to court to prove your innocence. Part of the reason, historically, that's very hard to do, to prove a negative, to prove that you didn't do something. But the state has the burden. Defense doesn't have to put on any evidence whatsoever. Does everyone understand?
Yeah.
All right, defense, you may continue.
And on that point, we all understand what the law is. And one thing is the law, and one thing is what we think and what we expect. And being against or not agreeing with the law is not wrong. It's our privilege to say, you know what, that's a law, but I don't buy it, right? I still think that to be fair and to do this, I need to have him to disprove his guilty, or, you know, to prove whatever. So you,
In the instance that we're being here to call to present a verdict, just like the gentleman here said, is like you said, conscious bias.
Yes.
Of how we were raised, family, everything, that also takes into part to what we're gonna decide, whether he decides to present evidence or not.
Sorry.
So, in a saying that we have to go based on what we're presented, our upbringing is still gonna bring that verdict to where we decide. It might not be, but like if he does, it would help for him to have evidence supporting himself and not just the state. That's where I'm trying to get my point across. That's where I would give my judgment, my jury, or whatever you call it. But that's what I was trying to get across. Like she reiterated what the law is, yes, but our upbringing is who we are, regardless of what the law says. You understand?
I understand, and that's exactly, that's very insightful question or answer, because that's exactly what we're talking about. We're talking about bias, because we're human. And the law says something, but our feelings say otherwise. And sometimes we say, you know what? He didn't bring anything because he did it, right? Because why? Who's not defending himself? Because we're accustomed to when somebody says, "Oh, you stole, you took the cookie," and say, "I didn't," right? You just come right and you said something, and you do that. So you're still in the position that.
But does he have the right to do that? To present evidence?
Yes,
So it's totally his choice if his lawyers, if they want to or not.
That's correct. 19. And so it's very important because it's a choice, but at the end of the day, who's gonna be deciding his fate is 12 of you. And the 12 of you have, as everybody's, the word is going around, like implicit biases, confirmation biases. It's all kind of biases that prevent us to do something. It's gonna sway us one way or the other, no matter what the law says. And so saying that, would you still agree that you cannot be fair if you?
No, I cannot be fair because, like I said, in my mindset, that's
Are
how
you-
I was raised.
Yeah, your number again?
Oh, 38.
38. And so 31, I see you shaking your head. Do you agree with that? Yes.
Do I agree with what?
That you would require him to come in and prove his innocence or anything with some,
wouldn't.
no. So you agree with everything that's been said?
Everything that's been said, sorry.
Yeah, that he doesn't have to do it, that is solely on the state's burden.
Yeah, I agree, it's the state's burden.
Okay.
And counsel, you have 3 minutes.
So, yeah, number 63.
I would agree with juror 38 over there, that kind of hard to win an argument with these people if you're not gonna be there to testify for it, so. Or to, like, be there to say, hey, I'm not guilty. I'm not gonna stand up for yourself, I supposed to.
So you feel that you'd be biased if he doesn't put anything?
Correct.
Yeah, thank you. Anyone else? 59, yeah, I would feel like you. Can you step up, stand up?
This way I feel too.
You feel the same way? Okay. Anybody else? So now, think about this, right? And the presumption of innocence is enough for you to find Mr. Travis, man Travis, not guilty, right? And as such, the burden is on the state. And so we kind of reverse the roles here. And if you get to the jury box, what you're going to be actually judging is the state's case, right? You're going to be judging their officers, right? Their work, and they have to prove their case, right? You're not actually, semantically, you're judging Mr. Man, but technically, you're here for them to prove to you that their officers did the right job, they collected the evidence, and they are truthful. Does anybody disagree with that? And I need to move fast, sorry. So the burden of proof is the most important thing sometimes. And so this is just an example of some standards. And this is the high standard on the other side, on the civil side, to take your child away, right? And that has to be so convinced, a firm belief of conviction as to the truth of the allegation sought. So it's a firm belief. It's not like, oh, I think it happened. It may not happen. I think I'm almost there. It's a lot more than that. Okay. And now coming back to juror number 41. What would it mean to you, the standard beyond reasonable doubt? Yeah, well, you know, we see this, that you have a firm belief of something happens, right? What would it mean to you? What does mean reasonable doubt to you, beyond reasonable doubt?
Oh, I'm sorry, I
Okay.
can't hear. And
She
counsel,
doesn't
your time has expired, but I'll let you finish with this juror.
Okay. No. Okay. And so you just one last question. Can you look Mr. Mann in the eye and tell him that he's not guilty? No? Thank you.
All right. Thank you. All right, ladies and gentlemen, I'm going to let you all take your lunch break, and I'm going to have you all back here at 2. You'll need to be lined up outside at 2, everyone. Does everyone understand?
No.
And this is what I suggest during your break. Excuse me, during your break, if you have not got your parking validated, make sure you get that parking validated. So we'll have you lined up outside at 2 p.m. All right? All right, everyone, please rise for the jurors.
But,